Can I book who decides
eventually nobwedda onasaba busabi tuyingire nabo bamanyi abo kituufu nti mbadde nkyatereeza wano emesagi kweziri YouTube or Facebook? You tell me when it's back, you tell me when it's back. It's all about network. When the volume is off, you just get to know that the network is kind of disturbing. But you let me know when the volume is back. Yeah, they tell me the sound is on. Paulo Kasawa mukama wange ebiri mundu genda bifuna naye ya Procedural no Kooti Yamajje. This is a court martial. Yes, kindly just tell me where are you watching from? Where are you watching from? Where are you watching from? Just write down where you watch where you
mwasuze mutya baganda bange kansule nti muli bulungi. Bakomezedwaawo TV, YouTube buterevu ku Kooti Yamajje omusango gwa Dr. Kiiza Besigye ne Haji linnya ndyerabidde sorry. Omusango gukomyewo olunaku olwaleero mukuliko eyo mwenna be twabadde nabo ababadde online abazze physically kuwerekera muganda waffe Ssegirinya. Muganda waffe Ssegirinya twamulese embitooke yekka. Ssegirinya twamulese embitooke yekka naye essaawa zino tuli ku kooti. Tuli ku kooti emakindye tulabe nti tubaweereza okuba nti buli kimu mukiraba. Buli kimu mukiraba. Dr. Kiiza Besigye akomyewo. Wabula kyetutegeddeko kanso waffe oli Aaron Kiiza erooya wa amawulire mugende muveewa. Aaron Kiiza bwe yakwatibwawo mu kkomera muganda wange bwe bamukwata awo okumuteeka mu kaduukulu abasibe be baamutaasa era tutegeezeddwako nti ali ku ndiri tutegeezeddwako nti ali mu kufuna bujjanjabi baakubooli kanetiwaaka katono naye tujja kagumira akakwatamu awo netiwaaka si nnungi nnyo wakakwatamu mukagumire tuli mu Uganda buli kimu kisoboka so abagamba ate kakati eno TV tulina obbalaga buli kimu ate munaamanya muti ekibi oba ekirungi nga temukirabye so tulina abantu bangi abatugoberera nga bino bajja byetaago biraba nabo era gwatabyetaaze muganda wange era oba waddembe obikola ki obiyitako naye ate gwe bwe bikikwatako ne bw'oba toyagala Dr. Kiiza Besigye oba waddembe okukola ki kanetiwaaka katusumbuwamu ku katono nga bwe kabadde mu kusooka naye tugenda kubawa byonna ebiri emakindye mu kooti tugenda bawa byonna ebiri emakindye mu kooti mubifune so bwekakwatamuko ate nga mutuddira bwekakwatamuko katono mubeerako katono gwe gireke ewaawe eroolinge nga mutuddira mpola mpola naye tujja kubawa buli kimu kyonna nga bwe kigenda mu maaso baganda bange abaliko ku Makumirya TV yes nga bwe tukyalinda netiwaaka wano etereere nyongera okukulisaayo baganda bange mwenna betwabadde nammwe kaddugala nsooka okukulisaayo baganda bange mwenna abafuuti soja okusookera ddala abafuuti soja mwebale kukuuma kitiibwa kya pulezidenti ekifaananyi nakyo kiikyo kikomyewo mwebale kuuma kitiibwa kya pulezidenti Robert Kyagulanyi Ssentamu mwebale kuswaza abantu mwebale kuswaza bantu abatulowoozesa nti tuli violent for we just keep law and order we are not violent mwalaze abantu nti you are not violent mwalaze abantu nti temuli violent Katonda n'ayamba buli kimu ne kigenda mwebale kukuuma kitiibwa ebyaddala essaawa zino ekyaddala singa essaawa zino Ssegirinya bamuwambye ne bamutwala eri Mpuuga singa yamuwambye kyadde kityobola butyoboozi kitiibwa kya Ssegirinya n'okulaga nti eno ye pate so mwebale tulabe wano soke muleke tufune wano ku ddoboozi
Yes. Tell me, where are you watching from? I'm already in.
Okay, tugenda maaso. Mpuuga oba yavuddeyo ku kitanda batugambye abadde ali kitovu mu ddwaliro okusinziira ekyabaddewo sajja yalwanyisizza accountability y'eggulo ngenda bagamba nti buli kintu ng'ayagala alabe nti bw'anaayogera yafumbye emmere y'abantu bwe bati ng'abantu adde ategeese okugamba abantu nafumbye emmere y'abantu emitwalo 10 naye njagala kugamba gweva ku muntu gw'ogamba nti yakulonda n'akuzira va ku muntu w'ekyalo okugaana okulya omuceere ekyo ekintu kinene nnyo baganda bange omuntu w'ekyalo tugenda bawa byonna ebiri mu kkooti temufaayo omuntu w'ekyalo okugaana okulya emmere babboyi omuntu w'ekyalo omujja ku nnyama n'omuceere abantu abatuuze twabadde mu mukungwe nyendo mukungwe eya Mathias Mpuuga naye va ku bantu okugaana ne bazira emmere nga sigama twadde Bukoto sigama nti twabadde eno Busiro East ewange sigama nti twadde Makinde twabadde nyendo mukungwe Kaddugala mu constituency ya Mathias Mpuuga Nsamba abalonzi bagamba abamu wakalu bakamuweera kuki bakamuweera ku mazima yala kubanga bwenteekayo wano nfuna ku ddoboozi wano mpola mpola banjala nemba nfuna ku ddoboozi enjabawa yaddiba wampola
Soko jike nze sivaawo
kyakuswavu nnyo nojja abaana ewali omulambo gwa kitaabwe ne batamunaaza kubanga mbutuufu olina okutwala kale singa baba batutta abaana abo nga bamaze okunaaza kitaabwe n'obatwala eri ng'okusaala kutuuse kale n'ovaawo naye n'otakkiriza basaalire kitaabwe n'ekintu kye mugamba nti Nuupu yawambye omulambo ate kati yaguwambye ng'egujjawo eguteekawa Nuupu yasanze busanzi mulambo gwe baatadde mu maka Nuupu yasanze busanzi maiti ya muganda waffe Ssegirinya mu maka g'abakadde era we twabasanze mu ddiiro era we twaziise kati Nuupu yawambye omulambo n'egujjawo n'egutwala gye baagulidde Ssegirinya ettaka maama waffe yagenze n'akola statement n'agamba n'eri waffe twagulayo ekisaawe ddala ne maama oba abalala bakiwulidde maama oba bambi yabadde ayogera bambi yabadde aliko kazito oba bambi mwana yamulumye ennyo ng'era bwe kiri kitalo nnyo maama okufiira omwana oyo Ssegirinya atulumye naye munaye temusobola kugula kisaawe kiri maama statement eyo gye wakoze yayongedde tulaga nti mbutuufu maama temusobola kugula kisaawe kya Kereziya nga yabaguzaako kisaawe kizibu maama wakozemu kaawe ensobi nti maama nti ate munayina wali waffe twagulawo omugenzi bwe yagamba nti yagula ekisaawe kya Kereziya tekisoboka naye nga kitalo ddala ate maama walala we wasuddemu Mpuuga abadde atuwa nnyo ssente era yampadde ssente naffe tujja zikuwa 10 okusinga okulya $5,000,000 omulundi gumu n'okoma ku ezo naye nga ojja kusobola okufuna abazira kisabadde bakwano Basegirinya basobola okuwa $1,000,000 buli mwezi ne bakuteekako wakiri nebanga payroll kubanga era Ssegirinya adde akuwa mmeka omwana tasobola kuddizibwawo naye abantu basobola okuwa $1,000,000 buli mwezi $12,000,000 omwaka basobola ozzikuwa abantu batuwulire wano Kooti etudde tuli Makindye mu kooti mapu tuli luddawa tuli Makindye mu kooti ebigambo biibyo biwandiikiddwawo Dr. Kiiza Besigye ne gundi akomyewo Haji Lutale, Dr. Kiiza Besigye ne Haji Lutale bakomezedwaawo. Sempala ogamba otya? Okay, Sempala Jamiru ogamba otya wefumbe? Mbaraza Ronald, Dr. Kiiza Besigye. Good morning map erinnya Sola Desoma BSJ. Ne mwetume kumanya. Manya agamwe. Njagenda ku kundi, njagenda mu byafaayo nti nange map yenze ate nti gwani nti nze nali dididididididi wano. Okay, kooti etandise. Kaffe katusirike. Tugende mu maaso.
Together with Bakomezedwaawo, Mr. Munne Moses, Ms. Kiiza, Mr. Silas Kuku, Mr. Peter Nightway, Mr. Bayan Namkama, Mr. Mr. Michael Chimuku, Mr. Abubakar Sekanjako, Mr. Kato Wilson, Mr. Elias Alcola, Mr. Katimpa Godfrey, Mr. Wanda Ronald Samuel, Mr. Frederick Banga, Mr. Katumba, Mr. Kabir Lawrence, Julius Paul, Mr. Samuel Bigwa, Mr. Chizito Farouk, Kamuledia, Mr. Nap Dennis, Mr. Moses Kabusu, and the other council who is not present is Mr. Kiiza, who is still council for Honorable Chair, we have some housekeeping issues that we need to deal with before we the Chair allows. Handled by my starting off with the council. I believe it is
the court. One of the housekeeping issues is regarding our right of access to the court as advocates representing the suspect in the law. And looking at regulation number 60 of Uganda People's Defense Forces Act, regulation number 1. This regulation gives you, Mr. Chairman, the duty to ensure that this court functions as any other court of law. And in any court of law, advocates are granted access to the court to be able to do their duty to represent the accused persons. Because of what transpired here last time we were here on the 10th, when Aaron Kiiza was denied access and it resulted still being held. We are most humbly seeking your assurances that as advocates, we are not going to endure any intimidation or obstruction as we come into court to do our duties. I must state that what transpired has caused a lot of shock. If you can see, we are lesser than we normally are. It has caused fear and intimidation among the ranks of advocates, and we thought that we needed to bring to your attention that this court needs to show and to demonstrate balance, not just the welfare of the military officers before it, but the welfare of everybody in its presence. So we are seeking assurances that we'll be able to represent our clients without intimidation. And today I must state that we have ease of access unlike other days. Today we have even been facilitated to sit together where we can be able to pass news to one another. We thought we should bring that. The other issue is of officers who are manning the court not having their name cards. So we are not able to know who is interacting with us, and it is necessary because it's procedural that any officer who is officiating at the court should be disclosed. An issue that is may not appear very relevant, but it is. We have noticed the changing composition of the court, that sometimes one or two members are replaced. And we are requesting when that occurs, kindly let us know who has been replaced and the names and the rank of the person representing them. You remember that at the start of the court, the names and ranks of all members of the court were read out. But at that time, these two gentlemen, so when they change, it throws us off balance. We are not able to know the composition of the court, which is a requirement. We have other housekeeping issues, which I will leave my colleagues to add to. And maybe before he rises, to my colleague, professional colleague, the judge advocate, just to tell him that yes, I'm from Kenya, but I'm East African, and I'm an East African passport. So the unkind reference of me as a foreigner is not last time. It's not applicable. I'm an East African holding an East African passport. So apart from being licensed to practice law here, I come as of right being an East African. There is one other issue that I was required to mention before I hand over to the Lord Mayor. It's just about the terminology. The last time, the judge advocate actually said that I would also be subjected to contempt proceedings for referring to this office as tribunal. Whereas we are trying our best to keep saying court, I just wanted it to be on record, Mr. Chairman. The word tribunal is not derogatory at all. Tribunal refers to a court in the Oxford Dictionary, and I hope my people has come with the photocopy. It refers to a specialized court, like yourselves, which is dealing with a specific court, a specific. You are not dealing with general matters. For instance, a Ugandan who is a landlord cannot come and file a claim against the tenants before yourselves. You are settled for a particular purpose. That's what tribunal means. And therefore, I will plead with the judge advocate, please let us give the proper terminology, proper interpretation, because they are bound to take your interpretation if nobody objects. But if we object, then the court, led by the chairman, has a duty to see whether our objections are valid. So I would like to refer to the English.
For me, if I interject, the word court is defined in the United Act. We are not going to adapt the dictionary definition. use the UPDF Act to define what is the meaning of court.
Like
And
that.
that is the one we shall go with.
That exactly is our problem, and
Which was enacted by the parliament.
it is
So
true.
outside that, unless you go back, I'm starting from
Mr. Chairman, we seek your indulgence in listening to our objection. The English language is neither defined by the UPDF Act or even by the Constitution of Uganda. The English language is a foreign language, and meaning is found in either legal dictionaries or reputable dictionaries in the world. And therefore, the word tribunal court, which is an English language word, must be defined. And I say Article invite you to check the word tribunal so that we do not undergo threats of being imprisoned for using the word tribunal. It's not derogatory. It can be used interchangeably. And what I'm really hinting at is that the interpretations of the judge advocate must be as closely as possible to reality to avoid misleading the court into acting in a manner prohibited by the Constitution of Uganda. I hand over to my colleague.
Thank you, Mr. Chairman and members. Mr. Chairman, I sort of substantiate these issues with prayers. Number one, Mr. Chairman, issues raised by Senior Counsel are quite fundamental in the administration of justice before you go by this court-martial. From the list read by my friend here, Council Kalibala, the name Kiiza remains on the list as one of the advocates representing the chosen aspects. Mr. Chairman, we seek your guidance on how that is going to be handled, because the instructions still stand that it should be part of the team. Despite what transpired the last time we appeared here, the procedure was so underway. Mr. Chairman, you're wondering whether there will be orders, but by the time the proceedings come, you have discretionary powers that to be produced here to execute the duties, and then maybe his return. But we leave it to you, Mr. Chairman, to guide us on how we are going to deal with that, because it's a matter which touches legal representation of the right of fair hearing, initially in Article 28 of the Constitution. And as we indicated earlier, there is a specific role he had been assigned in representing the chosen persons. So we beg to be guided, Mr. Chairman, in how Kiiza is going to continue featuring these proceedings as one of counsel. And we ask that you pronounce yourself on this particular matter. Two, again, we ask, Mr. Chairman, that you pronounce yourself on the validity of the proceedings conducted when the tribunal, rather the court-martial, the panel changed. When the panel, the composition changed. Because as per Regulation 26, Mr. Chairman, the sub-regulation 1 the order convening the court and the names of the officers appointed by the accused person shall be read in the hearing of the accused, who shall be given an opportunity to object to any of those officers. Indeed, at the commencement of the proceedings of day one, the names were read. But subsequent to that, as highlighted by my senior colleague here, the panels kept shifting. So, the panel that was announced on day one is the panel that was to have continued. Even on the day Kiiza was tried, summarily and convicted, it was a totally different panel. So, Mr. Chairman, we beg that you pronounce yourself on the validity of the proceedings that transpired after the panel had changed. And that is also fundamental in line with Regulation 26 of the regulations of this court-martial. Now, on the question of intimidation of lawyers, it's a very serious one. We beg that you critically reflect on this. We are concerned that the war environment is not conducive for dispensation of justice. As she has noted, and we are on record, you can see our numbers are shrinking. We are shrinking because of the intimidation of this program. There are orders that were made by you, Mr. Chairman, that all the officers manning the processes right from the point of entry should be clearly identified. They should have name tags. But we continue to have officers who are obeyed, whose faces are not even recognized, who have no name tags. So I don't know who we are dealing with, Mr. Chairman. And this is a known practice. I can see, Mr. Chairman, members who are part of this tribunal, Mr. Chairman. Their names were announced to us. And it's not without a reason that that provision was enshrined in the rules governing the proceedings before you. Why should we continue to have officers all over manning the courtroom here, manning the premises, handling all these protocols here we go through? We cannot disidentified. And they create the environment to be very, very inimical to dispensation of justice, very hostile, Mr. Chairman. And this is a key tenet of the due process, and it's a key tenet of the right to fair hearing, which is the bedrock of our criminal justice system in this country. We request that, Mr. Chairman, you make the environment conducive for administration of justice. It's a well-known principle, Mr. Chairman, that justice must not only be done, but it should also be seen to be done. So it should be manifested in the proceedings, in the way all the processes are conducted, and in the way we are treated. But, Mr. Chairman, the perception, and the reality is no conducive environment. And finally, Mr. Chairman, on the nomenclature here, which is turning out to be controversial, the issue of the tribunal. I thought they wouldn't be fast about it, because we use these terms interchangeably, even in the course of judicature. Mr. Chairman, it has happened even in the Supreme Court, to refer to the Supreme Court as a tribunal, to refer to Chief Justice as an arbiter. And the Chief Justice does not take offense. And to refer to his office as an arbiter, or to refer to him as an arbiter. The Chief Justice does not take offense. Ordinary courts of would not take offense to refer to them as Now, I'm worried if that is going to invite disciplinary proceedings, just even if it's a mere slip of tongue, that is going to invite disciplinary action. That sends chills down our spines, and it has a chilling effect on the execution of our duties. That chilling effect is so fundamental in the dispensation of justice. If I may ask, Mr. Chairman, I have had some of the officers here addressing us, your lordship. Say, my lord, my lord. Yet, for us, we are addressing you as a chairman. Would that also be taken to be undermining this court? That we are not addressing you as my lord? That we are addressing you as a chairman? And if the judge, advocate, and the entire panel shouldn't take offense about this, we can interchangeably refer to you as a court, we can interchangeably refer to you as a court martial or as a tribunal, because they all mean one and the same thing. But one fact remains, if we are talking about courts of judicature, that's a different matter, Mr. Chairman, because courts of judicature are well defined under the Judicature Act. And that is a different matter. So if I said this general court martial is not a court of judicature, I am stating facts within the law, under the Judicature Act, under the Constitution. That is not a court of judicature. And that is a fact. So, Mr. Chairman, I beg that you do pronounce yourself on those matters, fundamental, and the dispensation, in regards to the dispensation of justice. I beg to move this.
My name is Samuel. Mr. Chairman, I raise two issues. First, the RAS this side will have a better conducive environment this morning. The same was extended outside. Some of us have to walk a kilometer to court. Right from the T-junction, we are faced with the blockades. I don't know why the council cannot be given access to park within the premises of the court. I believe this is one of those issues that have to be taken seriously. How do I carry a box full of books from the T-junction or in the fields where we are being pushed to park? I think this should be addressed. We've seen a large parking space up here, in the premises here. So that should be handled, Mr. Chairman. Secondly, are we duly constituted as a court in the absence of reserved members of the court martial? We need to be guided on this issue too. Right. Mr. Chairman, short one, very good part. Regarding what my colleagues have said, vis-a-vis using the word interchangeable technology. Mr. Chairman, in our Constitution, Article 151, which is at page 130, which touches on courts. kindly request that that's the point in time basically to go to the Constitution so that it is not taken to be remaining members of the parliament.
Let me summarize this. We start from the bottom. Council member. This is what council member said. By the time I came, I did not even see anybody in the room. So I can't tell unless I have to contact people who are managing the security. But on that one, I can't tell much about that because by the time I passed there was nothing. But
Is the
if I'm
volume
not
back?
mistaken,
Is the volume back? You let me know because it is about the network. It is not about the volume putting it down.
much as you want to bring us in almost all issues, I think somehow, some of you need to bring yourselves. Council Dwaawo, you have been talking everywhere what you are intending to do. And I think they cannot be taken lightly. Because we need security. People who come here need security. And we don't know the tactics you want to use to destroy this court. We don't know. So, security also have to check if they have been checking people who are coming. I think that's what it's all about. Because I don't know what they were asking you, what they were telling you, what they... I can't tell. But I believe would have managed maybe from those statements sometimes we make. And on Council Aaron, I don't know really what you are pushing because I've never had, unless people will guide us also on that one. The person who is serving the sentence come and attend the court and be advised on that. Senior counsel, I don't know, you said, I don't know where this one came from. You know, of course, you are from Kenya, and Kenya is part of the East African community. So I don't know that one where it came from. But I think even the village once you serve from Kenya or Tanzania, it's good you have talked about the conduct today. And you remember it was already the other time, and you said I'm going to talk to these people. And that's what we want. We are not here just to, it's not a war. And I don't know why you are looking at one side, you are not looking at another side. People making noise in the court. To the extent of people standing on the chairs which they are not supposed to sit where they are supposed to sit. Singing, is that a court? Or you want to make us, you want to, you are either provoking us or you are, I can't tell why you are doing that. What we need is to conduct yourselves in the manner you are supposed to conduct yourselves. This is a court. I've seen it everywhere at once. The council, or anybody is submitting, everybody is listening quietly. You finish another one. If this side finishes, another side also, so that we proceed without any problem. I don't see where confusion comes from if we are following what you are supposed to. Unless if you have, especially council was asking about my vote versus chairman, and then the reserve members.
Yes, sir, I will take the opportunity to respond to the legal issues arising from the submissions of defense lawyers. And I also refer them carefully to reference 63, which talks about the duties of the judge advocate, Resolution 1, saying that the prosecutor and the accused respectively are at all times, after the judge advocate is named to act at the trial, entitled his opinion on any question of law or procedure relative to the charge of trial, whether he is in or out of court, and the accused and his lawyer. That's what it means. So, any legal issues arising, I am mandated to advise this court. To begin with, calling this court a tribunal, that one will not happen. The UPDF Act defines court-martial as field court-martial, general court-martial, or court-martial in court. That is what a court-martial is. Even in the Constitution, it is there that you can, the DPP can have maintain over all proceedings apart from the court-martial. So to say that we are going to borrow definitions or to have slips of tongue, I think me as the judge advocate of this court, you must call this court a court-martial. That is the name that is in the UPDF Act. We are not going to adapt dictionary definitions. Secondly, the issue of Kiiza as one of the lawyers. I also direct you to read Article 28, Clause 3, Clause D. Sometimes I never to read because when I refer to read, they say I should read, so I will read. It says every person who is, right, that's the right to fair hearing, every person who is charged with a criminal offense shall, when you go to be permitted to appear before the court in person or at that person's own expense by a lawyer of his or her choice. I don't see where they have said lawyers of his or her choice. And in as far as I know, in all cases we have handled. However, right of the offense, you cannot say that when we have 30 lawyers here, Kiiza, who was convicted by this court, is not there, and therefore the right to fair hearing is violated. Then what would be your role here? All the lawyers who are here, if I may ask. Or can I say you are going to say it's a constitutional violation because a person who was convicted court is not there and all the over 30 lawyers are here, that the right to doctor is violated? My answer is no. And if you want to seek constitutional interpretation, you can seek a constitutional reference on that. My understanding here, they say a lawyer of his or her choice. You can have more than one if you can, but to say you can be 30 and Kiiza has a specific role, to me that doesn't make sense. I think I'm done with that. About the environment not being conducive, the person raising this matter is able submitting before this court. How can you say the environment is not conducive when you are saying all what you have said? Council Kwabo, for me, I don't understand what you are saying. Then, the issue of court members, when we started this session, all court members, including those in the reserve, were present. and all of the members before you have been following this case, have been reported. So the fact that you are seeing one is not there, whoever is there has been here from day one when this court started. So you cannot say that these are new members, we have an instrument appointing the members. You can cross-check. They are there and they have never missed any session when we are sitting. So there is nothing that members are changing without notes. That one also has not happened. The other aspect, I think the last one, I think the one raised by Council Panel, I will not go into it because I have already given my position. But Senior Council Karua say that me, as a Brigadier Tukachungu, I called you that you are a foreigner. I have to ask you if you have that proof, and which I never did, I will apologize. And if you don't have it, I also request you to apologize for saying I said you called you a foreigner. We have interacted, but now it has never come out of my mouth. That is my response.
Mr. Chairman, remind my friend here that it is actually on video. You refer to me as a foreigner.
You bring it.
And everybody remembers it has caused a lot of heat on social media.
No, bring it. But I never said so.
The court members, we are ready to proceed. This case was which court has not pronounced itself. There's no prior at all valid of the proceedings where the ban has been issued.
That's what he was thinking about. That's what
It's advertising the court. It's not that it's not. He was advertising to tell us that this is a regime that they are changing. Can he say more?
it's like this council process. Members of this court.
But if court pronounced itself on the matter, if you feel that you have proof that the court was not fully constituted, you have an avenue of appealing and challenge the decision of that court. But you cannot raise it here that court is going to pronounce itself. Court was properly constituted, it took a decision. Now, for you who is aggrieved and saying no, then we have a controversial court. Appeal with proof. They will give you an answer.
Therefore, kindly give us a list of those who sat at the sentencing session for Aaron Kiiza, because we noticed there was a change. If you gave us that, it will help us in the appeal you have directed us to, because we definitely will take us the issue. But there's also one issue he has mentioned. He has said that if we are not happy with the interpretation, we can go to the Constitutional Court. So I actually rise to seek to be referred to the Constitutional Court on several issues, not just on that one issue. And one of the issues is actually the jurisdiction of this court-martial. I was looking at we have looked at the Uganda Constitution of Uganda, Article 208, which sets up the Uganda People's Defense Force, and Article 209. Nothing in those articles expressly or by implication gives the UPDF civil or criminal jurisdiction over civilians. And this general court martial was created through an amendment of the UPDF Act. And it is our belief that an act of parliament which amended the UPDF Act cannot amend the Constitution of Uganda. And that the Constitution of Uganda, the basic structure, which is about how duties are divided through the three arms of government, only the judiciary has the exclusive jurisdiction on civil and criminal matters, and that UPDF can only discipline its own members. These two gentlemen are civilians. We therefore want, among other things, interpretation of that. We also want the interpretation of the fact that lawyer, what do we mean by lawyer of choice? And by arresting and sentencing Aaron Kiiza when he is in court as an advocate. And the issue was the success beyond that bar, where now all these advocates are sitting. There's nothing else he wanted. He was saying, I will enter. Has that interfered with the right to presentation of these two gentlemen? Is it an act that undermines the preparation of the defense of these gentlemen? We have several issues that we would like referred and which we are going to draw your attention. If I may, I want to go over 2 or 3 of them and ask my colleagues to supplement. The first one I have indicated.
I thought you responded.
You asked us to refer matters of interpretation to the Constitutional Court, and I am now seeking a reference to the Constitutional Court.
Madam Chairman, what is referring to, Madam Chairman, I think she's going to address herself on the procedure, especially on references under our rules, Constitutional Court application and reference rules. And I don't think by submitting that she's seeking a reference to this court, that's what the rules provide. It doesn't provide that. There is a procedure that is provided for under those rules. Therefore, Madam Chairman, I pray that we proceed with what the merits of the case are, instead of going against what the rules of reference provide. I so
And maybe, sir, on the question of whatever you have raised, I have responded. So I don't see how you open again. The question of jurisdiction was the first thing we dealt with when before I took even the plea. And the ruling of court is there. So we cannot again go backwards from where we started. So all issues are resolved. As I read to you, regarding advising on legal matters, I have given my advice. So I beg you to proceed with the chair. Maybe Council was saying, calling you my lord, chairman. Nobody has forced you to say my lord. Even if you say honorable chairman, it's okay. But even if you say my lord, that's upon you. You cannot start challenging him that goes calling you. He has not requested anybody that call me my lord. You can call him honorable chair of the court. It's okay. So I don't think even the question was asking you that can he respond. There's nothing to respond there.
Mr. Chairman, just before my senior colleagues come, again, just for consistency, we kindly request.
Also, let's not repeat what has been said and answered.
I'm not going to repeat, Mr. Chairman.
Yes.
I'm only asking that because we are amending, if we could kindly follow a process whereby if the matter is raised to the level of court, we understand that the role of our colleague is to advise. So we take it that when advice is issued by the judge advocate, the matter then returns to the court to make a finding that the matter either rests or is left open. And why we are saying so, Mr. Chair, for example, is that there was no finality. Before I say that, otherwise, Mr. Chairman, it will appear
then that if an issue is raised by counsel and the judge advocate issues advice and the court does nothing after that advice, then it means that the court is bound and subject and subordinate to the judge. Why am I raising this? Otherwise, my Lord, there appears to be a difference between counsel and the judge advocate. Regarding the issues raised in housekeeping, there has been no adverse position from the state. In the other setup where we work, when you don't refute, you accept. It appears then that the judge advocate is either coming into the realm of the state and also being the realm of court. Why am I saying so, Mr. Chairman? There was an issue regarding the composition of the panel. And we take it, Mr. Chairman, that all the honorable members of the panel are part of the decision-making process of this court. The benefit we have is that when all of them are present, it is possible to follow the events, to look at witnesses, and come to a conclusion. It would be unfair to Mr. Kazibala, for example, if he laid his evidence before me and then he's cross-examined before Mr. Chiwanuka, and then the decision is made by Mr. Kawa. There is a break in the chain. So we kindly ask, before we go any further, Mr. Chairman, that the issue of the panel is completed. My neighbors whispered, and I'm sorry if they are wrong, but at the last sitting, your neighbor to my right, exactly, was not on the panel. I don't know why any particular member here identified only her, I don't know, but they insist that she was not on the panel. Other members before have said that there was one lady, now there are two. I think that causes a concern, and may go back. So it is an issue that if we break the consistency of the panel which constitutes the court, then the judge will advise that they are following, they may be following from somewhere, we don't see them here, but we bear in mind that the interests we are representing are for their persons, that they themselves, no matter the decision of the court, must be satisfied that the process has been fair and has played in accordance with the rules. So, Mr. Chairman, if the rules say that the members should be here, and it is good that they are here, so that, and I think that's a simple matter. If they say the reserved members are here, I don't direct, but perhaps the court can get a center so that we are happy that they are there and we see them and that we sort that. So I request, Mr. Chair, before and then we first state the reference, that we put to finality the issue of the panel. Because again, if we make submissions regarding whatever I want to say, and the court has to retreat, or the state has to ask for the time to consider, and the next panel is not the same, we will then have to make the same submissions just so that the person making the decision can hear the sound.
Mr. Chairman, on the same, my whisper was not quoted by him. I didn't want to stand again. I wanted to bring it to his attention that actually the neighbor does not have a name tag, just like the others. That was the observation. And it's clarified. Secondly, I think my issue of parking includes access, my access.
There is an advocate with who is
I'll not come back to this court if I'm parking 1 kilometer away. Access includes me parking in the premises. I think that needs to be also clarified by this court. We need a conducive environment as council, like his persons, and not carry folks of It's like I did today, 1 kilometer away from here, Mr. Chair.
Sorry, my neighbor is killing me. He says they say I should insist that the person who was sitting to your right the other day, in their view, appeared to be a gentleman. They alleged it is a name of Kalebo, and the collar was red. So we don't know whether so we don't know whether the person there has lost the red part. But my lord, as you can see, it's the concern that the people here in Basel, when they are changing, the concern that maybe may not be had fair and square. It's our collective Mr. Chairman, that the court makes a pronouncement before we go further regarding the consistency of the panel constituting the court. I'm sorry, of the panel constituting the court.
It's all right, Council. Yes, the other day there was a panel here, as you have said, but as you heard from Judge, we are 19 members. 7 are supposed to be here, including me, and then the reserve is supposed to be behind there, so there is 7. But maybe some could have misplaced by you can see it's that when in case one maybe have a problem of fields, you can go out another one can. That's how we usually operate. Unless we add on something, but that's how we operate. Then the accessing the court. Council, I may answer maybe from the gate here, around these rooms and inside here. But outside the rooms, I mean the gate, I may not have an adequate answer for that. And
I think so what I can inform the lawyers is that this part of the court is consistent of composed of 7 members before it can conduct business on any case of capitulation. We have 7. There is now no case arising before this court where Mr. Sara was not present. So we are ready for the case of concern.
Mr. Chairman, we need to put this in context. The spirit of the rule that requires that the name be declared at the commencement of the proceedings. The spirit is very clear. And actually it does not stop there. It requires that if there are objections to any of the members, the accused person is at liberty to say so. So if the panel keeps changing, like we are told, Captain Okalebo, Kano came in just to replace the one who had been on record before without any procedure being followed. That goes to the root of the proceedings, the validity of the proceedings. That have not had the pronouncement of the court martial, the validity of the proceedings, because it was not done on the day. Actually, Kiiza was summarily tried and convicted when Captain Okalebo came in. Kano Okalebo came in. When Kano Okalebo came in, there was no declaration made. And I've not had any pronouncement on the validity of the proceedings, which were conducted in outright violation of the regulation that requires that you make a declaration that this is the party that is going to try you. So this is the whole point we are making, Mr. Chairman. So if, Mr. Chairman, we continue operating like this, then it's a negation of not only the spirit of the Act and the regulation, but the Constitution itself, which Constitution is what is establishing this very court martial. So, Mr. Chairman, we need like reinforcing the submission of my client's very part. Let the court make a pronouncement, a decision.
Counsel, the culture here is, once a chosen person is brought to the dock for the first time, he's introduced to all members here and to members, which was done on that day. So this, or changing of position or relation, just is when we are proceeding. Or maybe, unless you are asking that, where is your Karibu now? That's what you are asking.
Not only that, the validity of the proceedings, the legality of the proceedings, where a member of the panel is not introduced because Captain Colonel Okai was never introduced to the accused person. This is the point. All the accused persons, these ones in the dock and the enemy chase, because he was also put in the dock as brief. So Okaribo was never introduced to the accused person.
I think you could have forgotten, but that is the thing that is done on the first day when the accused persons or persons appear in the dock. And they are asked, and they answered. They had no objection.
I'm sorry about the volume. I'm sorry about the volume. It is only.
You cannot say that Kiiza was supposed to take a plea. He was supposed to be defended. There is nothing like that when you are in contempt of court. Contempt of court, you must understand about how it is, the whole process works. So you cannot say that the panel was not introduced to him. Those procedures don't apply.
But I think you need to close the chapter of Kiiza because he was convicted and sentenced. If you are not satisfied, you know what to do. That one. I think let us proceed.
He's still on the panel of the lawyers.
So should we adjourn up to finish his sentence?
It's the guidance we are seeking from Mr. Chairman. How do we deal with this?
About
He has instructions.
About the convict, the one who is sentenced, who is starting the sentence.
But he still has instructions, Mr.
So which
Chairman.
means all of you cannot proceed.
I think it is very important what the judge advocate is giving as advice to this court. And I will here now declare that I've been a judicial officer of the rank of senior resident magistrate. And even in contempt proceedings, you cannot sentence an accused in their absence. You must put the contempt to them. So we are saying that procedure in this court will be very important, and it is of utmost fundamental importance, the advice given. And when we object to the advice given, it is important that the court, in accordance with the rules of procedure, pronounces itself. You are expected to side with the judge advocate, or for good reason to differ with him, because we are objecting also based on law, so that you are given the correct procedure. What happened to Aaron Pastor happened, and he is going to take action accordingly. But if moving forward, the proper procedure is not applied, then we are at risk. That's what we are saying.
I think, sir, we need to move forward, Mr. Chairman, and we close the chapter. All matters are with the
No, sir, we are closing the chapter, but what I want to tell the defense attorneys is that just feel free, unless you conduct yourself in a manner that is befitting you. This business of making noise, stand up, we go, we do what, that one is not going to be allowed. You do that, you are very responsible. Let us conduct ourselves the way we are supposed to conduct ourselves. We listen to each other and we proceed.
Allow me a light observation, Mr. Chairman. On the issue, yes, much obliged, Mr. Chairman. On the issue of changing the panel, Mr. Chairman, it has far-reaching consequences. For instance, well, when the ruling which resulted in split sentencing my learned friend Kiiza was being read, reference my Colonel Okalebo was not present in 2024. However, he participated in sentencing Aaron Kiiza. It has far-reaching consequences, Mr. Chairman. Indeed, something must be done. I thank you.
So, I think you need to give them the list, the other instrument of ours, so that they understand the conclusion of this code.
We have our one, and they are also advocates. They are there, they are sitting, don't just sit in their clubs. The media and the one makes, they are also advocates. They manage our registry, it is also under my office. So you can ask anything, if it is an instrument of appointment, we have it.
Go ahead, go ahead on this stage.
Mr. Chairman, just the last one, the very last one, the judges, Mr. Chairman, judges, Mr. Chairman, I beg, Mr. Chairman, no indulgence, Mr. Chairman. This is the very last one, Mr. Chairman, which you raised in your communication, Mr. Chairman. Mr. Chairman, if I may be permitted, Mr. Chairman. Mr. Chairman,
I think sir, lawyers cannot speak at the same time.
I am seeking for the indulgence of the chairman.
But he has not allowed you.
This is a rumble, I know, and
This is what we are saying now. Because if you are conducting ourselves like that, then we don't see.
because, Mr. Chairman, we are dealing with matters of life and
Since
death.
we started, we are talking. Now let's say.
Mr. Chairman, it all depends on the gravity of the matters we are dealing with. The sentence we are talking about here is dead.
Chairman,
The charge is dead.
I suggest you rail on also for a vote, is to respect the chair and vote. People lawyers cannot speak at the same time when you are not standing. It's better less.
Council Rafael proceed.
On the 7th of January, when this matter came before this court, I concluded this court that we intend to amend the charge sheet. But because of some administrative matters, we could not proceed, which happened in court. So, Chairman and court members, we want to amend the charge sheet and we are amending this charge sheet pursuant to Regulation 66 of the Uganda because of the first process and also procedure. It is premised on the need to ensure that justice is effectively administered by holding all parties accountable. So during the course of the investigations, some facts revealed that there is a serving UPDF officer who is connected to the offense. So we intend to have the charge sheet amended by addition of that officer. And we also intend to amend the charge sheet by adding there another count of treachery. So those are the two amendments we are seeking to amend. The person who is introduced on the charge sheet is Arako 743, Captain Dennis Ora. Rear Adult, Ugandan, a soldier of regular forces, Ugandan for the defense forces. And he is attached to Amadi Brigade.
Sorry, this is part of the particulars of the
So it is an RO 74 3. We are also acting there in the public of Rotary, which will be out too, including the officer and the two accused persons. Those are the amendments. We seek. Wow.
We object to the amendment, especially before the ruling of jurisdiction. In fact, we stopped the application for reference to await the ruling of jurisdiction. We feel that amending to add a person who is serving in the military is meant to preempt the ruling on jurisdiction. So the court has no, it's in our view that the court has no jurisdiction on these two gentlemen. And we see that the ruling precedes the amendment of the charges. When we then can raise full objection, because the charges, the amendment is not sought properly pursuant to the rules of procedure.
Council, which ruling are you talking about?
On the ruling that you referred to, Mr. Rukwako, having on your jurisdiction. There is a ruling you've been seeking to deliver ever since we came.
From the Supreme Court?
For yourselves, from this court martial.
That's what was given first.
Not the ruling. From the ruling which was delivered on the same day it took place.
Mr. Chairman, we have been under the impression that on several occasions that was supposed to be done. And that ruling relates to matters that were raised the first time the accused persons were charged. That matter has something to do with jurisdiction, it has something to do with the extraterritoriality of some of the offenses and how we got here, and therefore it's quite much. So we have all along been under the impression that this is a factor ruling. I do recall my land trade profile once actually was and said we are ready to proceed. But the events that have taken place since last week have not taken place. So we are keen on receiving the ruling. Mr. Chairman, that is point number one. Point number two, it relates to what the land trade has
looking at the rule that was cited, and it talks about amending charges where there is a mistake in the name or description of the accused, or a mistake which is attributed to a clerical error or omission. And he did say that in the charge there had been reference to the serving officer. I haven't seen that reference in the charge, but I don't think that calling somebody a serving officer is a clerical error or omission, so that now we have found the name. You must have known the name just refused to put it. So I'm not sure that regulation 66 allows him to do what he's asking than to join Captain Davis. So I just rise on those two issues. Ruling prior to whatever that is asking.
Mr. Chairman, for the record, I'm Louis Bazinamukoi. I associate myself with submissions of my senior land friends. Mr. Chairman, the move by the prosecution is a calculated way of defeating the defense which has already been brought to your attention through preliminary objections raised by my senior land friend, Counsel Elias Lukwago, when he objected the jurisdiction of this court. And indeed, there is a pending ruling. The other time when Senior Counsel Martha Karua came, we were not allowed to proceed with receiving the ruling, awaiting the grant of a temporary practicing certificate to Senior Counsel. Indeed, Mr. Chairman, there is a ruling pending before this court, and the prosecution is trying to, yes, if the prosecution refers to the notes they've been taking, they realize that indeed when we compare the same with ours, there is a pending ruling and they intend to preempt the ruling, Mr. Chairman. Don't allow them, they will be defeated. Yes, yes.
Mr. Chair, just for recollection, maybe recalled when senior colleague Karua last year raised an application for an adjournment for an hour, and court wasn't ready. Court graciously granted us 15 minutes. At that time, the business of the court before the adjournment was to deliver a ruling regarding matters raised by Mr. That was overtaken by events because when we came back in the afternoon, we did indicate to court that there were issues regarding instructions received by him and also the matter of Mr. Kiiza. So it is correct, if I recall, that it was at my request that we are granting an adjournment of 15 minutes so that we come down and issue the ruling of the House. Perhaps, Mr. Chairman, it may be necessary for court to retreat for 10 minutes just to confirm that it is correct that there is a pending ruling. That was issued of the House.
Council, honestly, I'm glad the regulation is 66(1) that we need to see to paragraph 2, which states at any time during the at which there is a judgment, it appears to the court before the process to resolve its finding that it is desirable in the interest of justice to make any addition
on each one. So that is the application. I'm moving because this is during the course of the investigation. Additional evidence was got and the person is active, and also another count is also active. With regard to the ruling, we are also expecting
just a brief between rule 66. I had read this rule 2, but my interpretation of some rule 2 suggested that it only applies when we are at a stage where the court is close to the deliberation is finding. We are still at the initial stages of this matter. So I still submit to myself either to the judge under this 66.1 doesn't help him. 66.2 certainly destroys his
Allow me, Mr. Chairman, to add just one thing.
my own, they have no locus.
We are relying on a matter of law to your application. Actually, the rules are so strict that once you charge an accused person, other than errors in name and at the stage of deliberation to make a conclusion, where the evidence may have revealed a different charge, you cannot add other accused persons. That's our reading of that particular regulation, regulation 66.1 and 2, and we are asking you to make a finding that they cannot amend at this stage. I want to thank the prosecutor for admitting that indeed we expect a ruling from the court of the area.
The court is adjourned for 10 minutes.
Okay, the court is adjourned for 10 minutes and we are taking a break of Besigye huyo awubira abantu Davis. All right. Court has taken a break of 10 minutes. We are coming back in 10 minutes. Still to sawa kumkwatira ke dakika emu yokka nkwateko mu nsawo yange. As you see what is going on here, court has taken 10 minutes for a break. See how they can come around. See how come around.
yes baganda bange omusango gukyagenda mu maaso waliwo ka buleeke tugenda kudda basajja bali mu ggamba enkwata gye bakwatamu n'entulugunya teyali feya gye bakwatamu munnamateeka Aaron Kiiza bakomplaininga eddoboozi nti liri wansi munnange kooti bwe zibeera kooti gw'otagambe mulamuzi babukangalu kooti nti mwongeze ku ddoboozi amaloboozi bwe gatyo bwe gabeera mu kooti zonna ezisinga boogera bwe bati omulamuzi tosobola kuwulira na byayogera abalamuzi bonna ye leero olaba obalamuzi bootawulira naye ate bano makindi kooti Dr. Kiiza Besigye akomezeddwawo naye ng'ensonga zonna bazigasse ensonga zonna zigattiddwa ne munnamateeka Aaron Kiiza yali alaga obutali bumativu bamugaana okuyingira ate nga ye looya y'omu ku balooya ne bamugaana okuyingira mu kooti kati mu kuyingira mu kooti ate bamugaana okutuula n'alaga obutali bumativu ne bamukwata ne bamusalira awo wennyini nga tawuliziddwa teyeewozezzaako ne bamusalira emyezi 9 ekitalya so yala tulabe oba tugenda kufunayo wano oba interview gundi wano tulabe ekigenda mu maaso oba katusooke tuveeko ko katono tugenda kudda katusooke tuveeko ko katono